good morning, everybody. Thanks for joining the webinar. I'm delighted to introduce Professor Don Wallace, whom I would characterize as one of the great American professors, to whom I'm also personally indebted, having had an invitation from him to become visiting scholar at Georgetown University 10 years ago. Don Wallace is the US delegate to the UNCITRAL Working Group 3 on ISDS reform, and author of Investor-State Arbitration together with Christopher Duggan and Noah Robbins. And he's one of the few professors I know in that hemisphere who has actually been dedicated Liber Amicorum essays in honor of Don Wallace. And I recall in the 90s, I think, I got hold of one of his books on subsidies. So Professor Wallace is quite active in different areas of law, in particular of investor-state arbitration, but also with respect to trade, infrastructure projects. And he has been obviously very active in those fields. Don, I'm going to pass the floor to you.
Thank you very much, Herfried, for your very nice remarks. This panel is on the reality of ESG claims, climate change, and investment arbitration. Let me make a few preliminary points. Changes are taking place in the arbitration system, and they will play out over the next years and probably decades. Bilateral investment treaties, BITs, and others are changing. The EU is removing its members from the Energy Charter Treaty so that claims cannot be brought against them with respect to climate-induced energy issues. But of course, there's a survival clause, which probably the host countries cannot escape. The investment protocol of the African Continental Free Trade Agreement removes FET, but imposes ESG obligations on foreign investors. It also permits some BITs. The question is, will future BITs impose these ESG obligations on investors explicitly or through a broad disputes clause? If they do, then counterclaims can be brought, as ICSID and UNCITRAL, of course, already allow. The real issue is this: even as there's an attempt to impose so-called ESG obligations on investors, which typically BITs have not done, how will they be specified? It's very hard. This is mostly soft law. How can it be made into actionable claims against investors? One thought has been that investors would be bound to the obligations of both their own countries and host countries' laws. Now, how that'll work, I'm just not sure. And then, of course, the question arises, how will investors defend themselves? Under investment contracts, which can be raised to a treaty level by an umbrella clause or otherwise, they will also come into play. And then how will investors defend themselves? Through hardship clause or otherwise, and indeed, how will governments defend themselves? So the truth of the matter is that investment arbitration and arbitrators face some really new changing realities because of climate change and its consequences. And to hear more about this, let us turn to our colleagues on the panel. And first, Herfried, please.
Yes, thank you very much, Don. I'm going to talk about damages in climate change investment arbitration. So perhaps you ask yourself, what's so special about damages in climate change investment arbitration? And what I'm actually going to do is to tackle a couple of discrete issues which seem to be overlooked in the current discussion on damages. And don't forget, damages is one of the topics with respect to procedure in the UNCITRAL working group 3. As you perhaps recall, I'm an author together with my partner Adriana San Romano of the monograph of the Oxford University monograph on damages in international arbitration under complex long-term contracts. And we just wrote also the second edition chapter on damages in investment treaty arbitration and damages in commercial arbitration for the book on international arbitration and European Union law that should come out next couple of months. To start with, I would like to cite one of these rather scandalous remarks that we frequently listen to. The report, a recent report by the United Nations, UN reference A78-168, entitled "Paying Polluters: The Catastrophic Consequences of Investor-State Dispute Settlement for Climate and Environment Action and Human Rights." That is dated 13th of July 2023 and delivered by the Special Rapporteur on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy and sustainable environment to the General Assembly at its 78th session. So, paying polluters: the catastrophic consequences of investor-state dispute settlement, that somehow reflects the current discussion that led to what Professor Wallace already mentioned, the non-signing of the reformed Energy Charter Treaty that actually included a carve-out of protection of fossil investments, but still, and also other tendencies that we're seeing starting from the crippling compensation movement to actually interference in UN meetings where damages are being discussed that are basically influenced by a small group of experts that basically represent a minority opinion that they made generally known. And that's what we read here. But what's the truth? As lawyers, we're obliged to check facts. As lawyers, we have to revise statistics and to make sure we're on the right path. And is actually really a right to damages, a catastrophic consequence. So let's go into detail a bit. And the thing I would like to start, and that's often overlooked, what's the principal function of damages law? And there first I would like to underline that damages are to a vast extent being determined by liability. So by raising or lowering the international investment protection standard, you would raise or lower the amount of damages to be awarded. And that is very, very important because it's often overlooked. It's not the fact that damages inhibit states from exercising the regulatory function. It's the liability standard. It's the so-called illegality threshold. If you put it up, make it more severe, then damages will be higher. If you dilute the fair and equitable treaty standard, then the damages are lower. And so damages are a mirror image of the liability thresholds, and damages as such never can interfere in the regulatory freedom of a state. So that I would say that's the first issue we have to take care of. Second, what's the principal function of damages law? Well, it's the compensation of loss caused by a breach of contract or an illegal measure affecting an investment. And that's not something that was invented with the factory at Chorso case, but that actually dates back a couple of thousand of years, starting with the Nicomachean ethics of Aristotle, where damages are an expression of justice and fairness, which was then further developed by the natural lawyers such as St. Thomas Aquinas in his Summa Theologica, which is not a theological works, but an expression of natural law, which I understand also was very important in the US and, of course, in great parts of the world. And both Aristoteles and the scholastic Thomas Aquinas developed what's distributive and commutative justice, which is the basis of all of our modern legal systems with respect to damages. And what the factory Chorso case actually did was to repeat or to codify something that in the mid-19th century was already a state of the art. In the mid-19th century, scholars like Mommsen picked up the Roman law id quod interest notion, and at the same time, a famous British case, Robinson versus Harmon, established that the aim of damages is to give the injured party the necessary amount of money to put him, so far as money can do it, in the same position as he would have been had the contract been performed. That's an 1848 case, and Professor Mommsen wrote his doctrine on interest around 1850. So what the Tursup case in 1927 did was picking up what was already standard in comparative private law. And as Professor Herr Schlauterbach confirmed, international damages is basically an analogy to private law at that time. So Tursup was 70, nearly 80 years later than when the leading doctrines on the European continent and in England had been defined. So let's go to the next issue. As I mentioned, the UNCITRAL Working Group 3 in ISD form is actually tackling damages with respect to procedural issues. Thanks to Professor Wallace, our colleague, Professor Irmgard Mavo, my partner Adriana San Roman, and I could comment on the UNCITRAL Secretariat's note on damages. I understand recently a new document came up. That note is pretty interesting as it reflects what I already mentioned, the crippling compensation movement. And I will explain that in a few words. The crippling compensation movement circles around, and also the UN note I cited at the very beginning, circles around 15 outlier damages cases with very high amounts that cannot be denied. The amounts are pretty high, but it's around 15 cases. They're actually mentioned in the annex to these UN rapporteur's note I mentioned at the beginning, and they're taken as argument that the whole system is wrong. But again, let's go to statistics. And as we mentioned in our expert report, submissions by governments pointing to the problem of high damages awards mentioned in the note, in the UNCITRAL note, seem to rely on outlier investment arbitration cases and give the impression that ISDS tribunals generally award very high amounts on damages. However, a recent study, which analyzes 241 awards until March 2020, comes to the conclusion that 3 awards alone accounted for 80.7% of the awarded damages, and the remaining average damages awarded were 52.2 million, 55.2 million. Another recent study analyzing 433 ISDS awards issued until May 2020 show that states won 54% of the cases. 2% were terminated, and the 44% of cases won by investors, the median amount awarded was 21.4 million. I repeat, 21.4 million. So that's the statistics, that's the hard facts. One of the studies was prepared by the British Institute for International and Comparative Law. The other one was published by Transnational Dispute Management. So if we go to statistics, the average was 55.2 in one study, and the median in the other 21.4. And that's the reality. But the question is, why do we have outlier cases in that such horrendous multi-billion amounts? And the answer is natural resources. Why? We all know who deal in this area and who deal with natural resources. Once you find gold, once you determine with a certain probability or possibility that there is oil, that there is gold, that there is silver, that there is what comes up now, lithium, then it has a value. Yeah. And that's not what damages experts say. That's what experts say who work in mining, who work in oil production. There is a value. So if the state takes away that value through indirect expropriation, through violation of the fair and equitable treatment standard, the state receives that value. Yeah. So it has to compensate in one way or the other. And normally, as those values are very, very high, oil reserves have a very high value, the compensation is very, very high. And that explains the outlier cases. And again, please read that report by the rapporteur. I can provide to you. There's an annex with 15 cases. That's what we talk about when we talk about the damages limit regulatory freedom of states. And that puts the statistic, put the discussion on a scientific basis, which is currently lacking. Just look at the ECT discussion, which is rather worrisome. And it's worrisome as Jagdish Bhagwati, I think he was, a very famous economist that was the brain of the GATT and the International Trade Organization, what ended to be the World Trade Organization. He once said, international treaties are there to protect states against their own populist leaders. Yeah, and that's somehow the truth. Also with the country where we have our head office in Mexico, where, you know, the government is of a certain type, very hostile towards renewable energies, and treaties serve to control populist politicians against their own populations. So a check, let's have a check, checking the system. And there's a very famous case that helps checking the system. Is the investment arbitration system and the damages system outside the scope of what states normally do in their domestic area or not? And I would say the leading case is Vattenfall. Vattenfall, recall, that's about the phasing out of nuclear energy in Germany. And there were two cases. One was constitutional litigation, February 2012, and the other one was the investment arbitration. Both cases were multi-billion cases. Actually, through a settlement, Vattenfall received 1.5 billion in damages, RW around 1 billion. But the interesting thing in the Vattenfall case, if you read the Bundesgerichtshof judgment, you will see that the reasoning on the measure of damages, and the measure of damages, the legal frame of what has to be compensated, is very similar to what has been argued in the ECT investment arbitration. So you see what is the standard or the mechanism of, or the scope of protection of investment protection in an investment arbitration is very, very similar to what a court, an experienced court would decide under a state system in a developed judicial system. Yeah. So that's just as a benchmarking of the system. Is the system right? Are we really in kind of exceptional spheres with respect to damages? No. Vattenfall proves that the system is based on quite reasonable and sound standards, also with respect to the so-called measure of damages that has been refined in the factory of Torso case. That is nothing else than the but-for premise with a certain causation theory, which is the hypothetical normal course of events. If you want to know more about that, please read our book and our publications. So next topic, investment arbitration and the Paris Convention. Now we finally are arriving at climate change. Well, the first thing is that most of the modern treaties carve out from investment protection, protection of health, protection of environment, the environment. So that's the general tendency. You find that in the USMCA, in the CPTPP, you find that in the Mexico EU global agreement, which is a second generation agreement that already contains investment protection. And if there is no carve out, then there's still hope for a kind of, let's say, modernized interpretation of the fair and equitable treatment standard, which should take into consideration somehow the Paris Convention. Article 31, paragraph 3 of the Vienna Convention on the Law of Treaties provides that when interpreting a treaty, any relevant rules of international law applicable in the relations between the parties shall be taken into account. That can be found in the Philip Morris versus Uruguay case. So when interpreting an international investment agreement, we should take into account the Paris Convention. And that Paris Convention actually has two sides. One is a sword, the other one is a shield. And the sword, I would like to refer again to Mexico, to rather hostile policies against renewable energies. And there's actually a USMCA consultation between the US and Mexico as regards the Mexican energy policy. It's a Chapter 31 procedure. It's not yet a panel. And that's about trade. That's not about the investment. But still, it has a 31 billion price ticket behind it. The problem with these procedures is they usually end up, and please correct me if I'm wrong, they usually end up with the suspension of benefits. That's a typical trade measure also under the WTO agreements. That means there are no damages. There's just suspension of benefits. And no one would expect that the US suspends benefits that is imposes import duties.
But you have 2 more minutes. 2 mehr Minuten.
Thank you. Danke. Suspends, imposes import tariffs on Mexican goods in the amount of 31 billion. But what may happen, and that happened in the Canacar case, NAFTA case many years ago, when Mexico achieved through a NAFTA panel that the US had to lift the ban on Mexican trucks. That was a trade case, was won by Mexico. And what happened afterwards? An investment arbitration followed, commenced by the Mexican Chamber of Transport, where based on the trade panel decision, an investment arbitration was commenced. The thing was settled. The US opened markets. So these US MCA consultations have to be observed. I understand that they're in a standstill right now, but they will not trigger tariffs against Mexico, but they might actually trigger a whole series of investment arbitrations against Mexico because of multiple measures hitting at renewable energies, self-consumption, energy production, and other issues, all of that mentioned in the panel report. So with that, I'm summing up the issue of climate change. Investment arbitration is a hot topic. It's inevitable, even if we see right now a backlash, but that is something to come, and we will be more and more engaged in those issues and how to combat climate change. And that, of course, will affect investments, in particular in the fossil industries, when measures against climate change lead to the impairment of investments. So it's something that has to be observed, and I'm going to pass back the floor to Professor Wallace.
Thank you very much, Herfried. I think the investor-state dispute settlement system will survive these pressures. And if you have this system, then as you've quite rightly pointed out, damage is an inevitable consequence of a government's interfering with the rights of investors under agreements and contracts it has agreed to. So I don't think it's all that controversial, but apparently it excites great numbers of people. Kiran, I think you're next. Am I correct?
Yes, you are. Thank you so much, Professor Wallace, and thank you, Herfried. It's really interesting that in order to analyze the role of ESG issues in investment arbitration and investment law, we need to go back to basics and break down, well, what are these areas of procedure and substance that we're talking about, and then how do they intersect with ESG-related goals or claims or objectives? So Herfried, I really enjoyed your presentation because we went all the way back to Aristotle to learn about damages and then also to see how that might intersect with ESG related claims. I'm going to do something a little similar. My topic today is to focus on the role of counterclaims in investment arbitration disputes, including how counterclaims arising from the right to regulate and ESG might interplay there. So I'm going to first start with an introduction to counterclaims. Counterclaims have been available in general in international proceedings and international commercial arbitration for sure for a very long time. Nearly all of the arbitral institutions rules provide for counterclaims. And to be clear, a counterclaim in an investor-state dispute is a claim that would be submitted by a respondent in opposition to the claimant's claim. So in that case, the respondent traditionally, and for the most, statistically speaking, for the most part, is often the respondent state. Investors initiate nearly all investor-state disputes. So although investment treaties are inherently asymmetrical because they provide investors with a number of rights, and we'll discuss whether they also have obligations, but historically they've certainly been asymmetrical in nature. States have always had the procedural access to initiate and submit counterclaims, which can help facilitate equality between the parties. So those would be claims submitted by the host states, and that would be a positive thing from a procedural perspective. It creates a lot of efficiencies, and because all the various arbitral rules provide for counterclaims related to the substance of an already initiated dispute to be adjudicated in the same proceeding, whether they're arising in relation to the exact same topic or in connection with related topics, it creates a really nice symmetry in the proceeding itself. And of course, we know arbitral proceedings, not only do they result in very high awards, but they're also very high cost and time intensive to put on. We know all the examples, and I'm sure we can name a couple of those cases when we speak about the crippling compensation cases as well that Herfried was referring to. But investment disputes can go on, those proceedings can go on for a number of years, many years, sometimes into a decade, if not longer, is what we've seen historically. But also costs mount as they continue. So rejecting a counterclaim has related waterfall effects. So if a tribunal were to say that a counterclaim cannot be asserted in an investment arbitration dispute, maybe it needs to go to a different forum, we can imagine the costs and time involved in investment arbitration related dispute to be catastrophically even higher than they already are. There's a great example in the dissenting opinion in an ICSID case from about 15 years ago, Wallace versus Romania, where the dissenting arbitrator pointed out that by rejecting a counterclaim made by the state may direct the state to its domestic courts. And if the judgment made by that domestic court is adverse to the investor, then there might be another bilateral investment treaty claim that follows. And that would result in the duplication of proceedings, inefficiency, and again, increased transaction costs. So if we're already in a world where investment arbitrations are very highly time intensive and cost intensive, counterclaims are generally available. And I'll go to the rules in discussing how they can be asserted. But directing them to any other proceeding can be inefficient. So you can imagine all the reasons why host states may be interested in counterclaims, not only for inefficiency reasons, but also because international arbitration, as we all know, we're here because we're proponents and interested in international arbitration. It offers great prospects for the future afterlife of the award when it's issued. If it's an ICSID award, an ICSID convention award can be enforced very easily around the world amongst the ICSID convention member states, can be recognized and enforced very easily. Other awards, such as those rendered according to the ICSID additional facility or the UNCITRAL arbitration rules, can be enforced in the New York Convention, which now we're at over 170 states and counting as parties to the New York Convention. So you can see all the reasons why states might be interested in seeing and pursuing counterclaims in those proceedings, in the investment arbitration proceedings. So having laid that out, let's talk about whether counterclaims are truly available in this setting. Counterclaims are helpful, they're a useful tool, procedurally they make sense, but can we actually have them in investment arbitrations? Well, according to the ICSID convention, assuming you're an in an ICSID convention universe. Article 46 of the ICSID convention stipulates that the tribunal, if requested by a party, may review and consider incidental or additional claims. So that is a reference to what we understand today as counterclaims. The ICSID convention's drafting history suggests that the reasons for including this in the convention was some of the same efficiency-related reasons that I described earlier, to eliminate the need and necessity of separate proceedings. And the drafters in their committee reports emphasize that counterclaims should be covered by the consent of the parties and should not go beyond the tribunal's competence. So we'll come back to the consent of the parties element, because that is a separate inquiry, as you know, in investment law. Further, according to the report of the executive directors of the World Bank when the convention was being prepared, it's meant to be equally adapted to the requirements of the institution of the proceedings brought by the investors as well as the host state. So you have a goal to create a lot of efficiencies in general in the ICSID convention. Now, what do the ICSID rules provide? As you all will know, the ICSID rules just went through a very lengthy revision and amendment process. It was an over 5-year work in progress with various public comment periods and revisions. Those new rules went into effect in 2022. I believe it was as of July 1st, 2022. And that was following the vote of member states of ICSID. So we now have revised ICSID arbitration rules and also ICSID additional facility rules. And if you look at the ICSID website, they do a great job of summarizing what are the availabilities and remedies for what they call ancillary claims. So now we have a few different words for what's the same thing. We have counterclaims, we have ancillary claims. The ICSID website also describes these as incidental claims, additional claims, or counterclaims. And as I mentioned, the ICSID convention itself also has its own terminology. It refers to incidental or additional claims. So we're seeing that these are all various ways to describe the ability to present related claims by the other side. The ICSID website expressly provides that those counterclaims should arise directly out of the same subject matter of the main dispute, should be covered by the parties' consent to arbitration, which is the next topic I want to talk about, and should fall within the jurisdiction of the ICSID Center, which is under Article 25(1) of the ICSID Convention or Article 46 of the ICSID Convention. So we have a jurisdiction of the center element, we have a consent by the parties element, and then we also have a substantive element of arising out of the same subject matter as the main dispute. Similarly, under the ICSID rules, counterclaims must be filed within certain time limits. They should not be filed, at the close of proceedings. They should not be filed at a time when they may be disruptive to the main proceedings. The ICSID rules ask that they be submitted at the same time as a statement of defense, and must be filed no later than with the party's reply. Counterclaims submitted by the other party and filed later than any of those counter memorials, as you can imagine, would undermine the efficiency, cost effectiveness, and other goals of having an efficient proceeding. At the same time, the tribunal can decide the briefing schedule on ancillary claims in consultation with the parties, and they can rule on such claims in their main award. But there is a procedural aspect to this, that the counterclaim should not be disruptive of what we will call the main proceeding. The UNCITRAL rules take a similar approach. The UNCITRAL rules, of course, started in 1976. They've been revised and amended a few times since. Not every revision process had resulted in very detailed substantive revisions, but the latest iteration of the UNCITRAL rules is from 2021, which in substance and form are quite similar to the prior iterations. For purposes of this discussion, Article 21 provides that the respondent can communicate counterclaims at the same time as its statement of defense. And it should do so again in a way that's not disruptive. Historically, counterclaims sought in these settings in the investment arbitration context have been quite limited. And they have coincided with topics I think Herfried is the true expert on, but things like costs, interest payments, or taxes. They're not usually independent and do not usually have an independent basis, but they are often very closely tied to the claims that are already present before the tribunal from a pecuniary perspective. On whether those claims should be brought, we should turn to consent. So I've been dancing around this idea of consent. Even if all the other requisite factors are met, you have a claim that relates to the same subject matter, you have one that's submitted timely in a way that's not disruptive, probably early in the proceedings, we have the issue of consent. So historically, as we all will know, the main aim of investment treaties and investment contracts has been to create balance between the host states and the foreign investors. And there's plenty of great writing from, maybe a decade ago, 15 years ago, talking about the need to have this kind of balance and the origins of international investment law and international investment agreements, because the conduct of the states is what needs to be regulated, not so much that of the foreign investors. And that was reflected in the language of those treaties. Those treaties explicitly provided that they had, they would have a preamble. That preamble would provide that they have a goal to protect investors and facilitate foreign investment. This is the world of the capital importing, capital exporting nations, where you did have sometimes a lack of equality between the host state and maybe the foreign investors, the investors being more traditionally privileged, and this is a way to make them a third-party beneficiary of the investment treaty, which could be viewed as a contract per se, but is not quite a contract, but it is a commitment and obligation. Those treaties usually only enable the investor rather than the state to submit claims to arbitration. At least that's been the case historically. Investment treaties did not provide for the submission of a state's counterclaims or mention the right of an investor to submit counterclaims. And some scholars have referred to international investment law historically, and also the right of an investor to submit such claims as sort of a quasi-judicial review process of national regulatory action. So in that sense, it would make no sense in that forum to have states submitting counterclaims. So you do have a consent issue in older investment treaties. If the state has never stated that it would intend to have counterclaims or make counterclaims in those dispute resolution provisions, then where does the consent by the other side, whether it's the home state or the foreign investor, actually lie? Because there's no perfection of the consent process in the jurisdiction of the tribunal until after the claim has been submitted, the notice of arbitration, by the foreign investor. So you have an open offer to arbitrate, and it's accepted by the foreign investor when it files its arbitration proceedings, perfecting that agreement to arbitrate the investment dispute. So you do have a consent-related issue. Typically, however, if the investment treaty makes reference to precise arbitral rules, such as those of the ICSID or UNCITRAL, and those rules make reference to the ability to submit counterclaims, that can be a nice way to assert the right to submit counterclaims, but you still do need to have it expressly referred to in the treaty. It's not a situation where you can a la carte select provisions that you like, add new provisions that you wish you had thought of previously under a different scenario, and create this environment where you have additional opportunities and rights. There's a great example. We were talking about the Energy Charter Treaty earlier. It's the AMTO versus Ukraine dispute, which was an Energy Charter Treaty dispute under the SCC, Stockholm Chamber of Commerce rules, where, for example, the Energy Charter Treaty did not reference the ability for a state to submit counterclaims. The SCC rules did provide the ability to submit counterclaims, and the tribunal ruled that the counterclaims were outside its jurisdiction because the state had failed to specify any basis for the counterclaim in its applicable law, in the dispute's applicable law. So it decided it could not go beyond the subject matter of the jurisdiction that was before it and declined to assert jurisdiction over the counterclaim. So in this world where we're seeing a lot of energy charter treaty modernization efforts, backlash to the energy charter treaty, in EU response, you can see that in a different world, I think the modernization process remains ongoing, it may have been wiser to have an ECT that covered a wider category of disputes or provided for investor obligations as well, where the outcome could have been different in a scenario where you might want to have counterclaims asserted. So where does this leave us on a substantive basis? We've talked a little bit about consent and counterclaims and how they have been manifested in the treaties themselves or in the arbitral rules. But the real issue is the treaties themselves. How complicated are they? How lengthy are they? How detailed are they? And I can tell you, I've looked at the first BIT that was ever entered. That was in 1956 between Germany and Pakistan. It's a 6-page treaty. And the font is very large. It has very few provisions. It's quite pro forma. It's sort of like a best friends agreement saying, we welcome your foreign investors and we offer them these protections in return. And that is really emblematic of what those very early 1960s, 1970s era treaties look like. They were all quite short. They might make reference to dispute resolution fora that could be accessed by a foreign investor, but not in any detail. And that first generation and second generation of treaties were all very similar in that way. They did not mention a lot about what the state's obligations would be beyond protecting the foreign investment. They also didn't mention how those obligations may be balanced against the state's right to regulate explicitly. And that was true up until the early 2000s. A great example is the German model BIT of 1991, which was very similar to other model BITs of that era, where it referred to the right to regulate only indirectly in the expropriation provision. And the old BITs had similar provisions on the protection of investment, but they did not really talk about the right to regulate. That tide started to change with explicit and affirmative protection with the, at least from my research, the 2004 US model BIT. So the 2004 US model BIT had a different approach to indirect expropriation and expressly reflected US constitutional law jurisprudence on regulatory taking. So you start to have a little bit more express assertion, which was also reflected same trend in the 2012 US model BIT, which also referred to assessments between states' regulatory authority and international investment protection, where it made reference to case-by-case, fact-based inquiry that requires consideration of many, many different factors. So you start to see the right to regulate referenced in treaties, in model treaties, as part of the negotiating process. And this became a way for states to ensure and design a process that protects legitimate public welfare objectives, because they do have an obligation, and this is part of the backlash to international investment law. They have an obligation to their nationals, to their state, to their taxpayers, and human rights and other things that may be implicated with that. So latest data, and this is my final point that I want to make, the latest data from UNCTAD, which is looking at these issues very carefully, is how fair and equitable treatment and the right to regulate are being reflected in all newly drafted or revised investment treaties. And some of the objectives that they are looking at, and that are also before UNCTAD Working Group 3 in their reform efforts, is that looking at the right to regulate can be a way to bring in ESG-related obligations. So if we tie the counterclaims opportunity with the right to regulate references that are now being made in the treaties, you start to see a little bit more balance. And the latest treaties I've seen, both model BITs and also newly entered treaties, make reference to a lot of useful emerging practices. One is the Paris Agreement, that the treaties will make reference to obligations that arise from the Paris Agreement. The other are the OECD Sustainable Development Goals, in particular the OECD guidelines for multinational enterprises. There's also UN guidelines like the United Nations Guiding Principles on Business and Human Rights. And perhaps most importantly, and as reflected in The US model BITs that I referenced are the local laws on regulatory environments, which can also include everything from labor laws to human rights to business laws. It can be a form of ethical standards, etc. So if you take that
30
all
seconds,
together,
Kiran, 30 seconds.
okay, if you put that all together, you start to see an opportunity to raise ESG-related questions in the counterclaims and assert the right to regulate, not only the right to regulate, but also ESG-centered claims in the existing proceedings that we already have. So there's a more balanced environment right now. I'm fairly optimistic that we have a place where we can bring ESG-related counterclaims in international investment disputes, but it's an emerging practice. I think we need to see how these treaties play out and also how these revised standards start to look like concrete obligations with benchmarks and requirements. And with that, I conclude. Thank you very much for your time and attention.
Thank you very much, Kiran. I do think counterclaims will introduce efficiency into the system, but I think your last point is also crucial. Namely, the investor has to consent to those obligations, and they have to be sufficiently specific that they can be practically actionable. And we'll see what happens. Devin, you're next.
Thank you. Thanks for the amazing panelists that have gone before me. I hopefully will be able to comment on both damages and counterclaims throughout. I also want to address Professor Wallace's initial question about whether and how ESG obligations can be imposed on investors. So hopefully that's something that also I'll have a chance to tease out. Also just like to thank the organizers of this webinar and give them the opportunity to speak on this timely topic of climate change and investment arbitration, which also has the emphasis on the role that ESG will play in that relationship. And it's certainly a dynamic time for ESG globally. At a macro level, various developments are challenging the customary ESG narrative. We were discussing a little bit about this before, but on the one hand, the narrative is being characterized as one of ever-increasing ESG commitments by the business community. This ambition has led to the embedding and operationalizing of environmental, social, and governance considerations in corporate strategies, making net zero commitments, and speaking out against injustices or threats of democratic governance, all while companies continue to make profitable enterprise or become profitable enterprises and generate returns for shareholders. That narrative, accordingly, could be described as the win-win or having your cake and eat it too. On the other hand, a narrative that has recently surfaced, particularly over the last few years, and which is driven in part by climate change commitment failures, the COVID pandemic, and the war in Ukraine. Macroeconomic developments have made ESG seem more expensive to pursue, and the political environment, especially in the United States, has seemingly fractured the ESG conversation. This past year saw calls for the end of ESG, exposures of companies engaging in greenwashing, and the highlight of flaws in certain rating methodologies and the suggestion of disbanding ESG terminology altogether. In short, there's a real tension. Some of it's good, some of it's not so good. And I think the road ahead is somewhere in between, and ultimately will lead to the identification of responsible businesses, and for our purposes, responsible investments and investors. For lawyers and other stakeholders in the field, this type of tension usually means disputes. From an academic perspective, and insofar as it concerns the development and advancement of international law, this, I believe, can be a good thing. And that brings me to my agenda. I have limited the scope of my presentation to discuss how ESG may function as a valuable resource to inform, develop, and advance certain general principles of environmental law, particularly concerning climate change commitments vis-a-vis investment arbitration, amongst other things. If I had a thesis that I could distill down, I would say that ESG has the potential, it's not there yet, but has the potential to speed up the development of international law by providing it with readily usable content, and investment arbitration is one of the catalysts that can give rise to that change. The roadmap for my presentation, I will discuss 3 main points. First, I will briefly touch on the general principles of environmental law. Second, I will discuss two key developments happening in the ESG landscape. And third, I will discuss how ESG disputes involving investment arbitration can inform and shape these general principles of law. I think for anybody that is watching this webinar, they are probably familiar with the sources of international law, custom, treaty, general principles of law, jurisprudence, scholarly work, unilateral declarations, maxims, soft law, et cetera, et cetera. My focus is on general principles of law, particularly since international environmental law is governed by many different principles of law, as you can see on the right-hand side of the slide. As there are no firm consensus on the constitution of what is a general principle of law, I've outlined also what some academics have regarded as primary features on the left-hand side. I believe the main takeaways are that general principles are legal norms. They exist amongst the majority of nations, that they operate to fill in gaps in the law, that they limit or guide adjudicators in deciding individual cases, and they are derived through some form of comparative exercise. I also note that Herfried has also raised that Article 31, 3C of the VCLT is a place where relevant laws laws relevant to amongst the parties can be used to assist adjudicators in interpreting certain things. And that's also one place where general principles of law can be incorporated into the analysis. On this next slide, I've provided a bit of an overview of ESG, primarily as it relates to climate change. It's a bit more expansive than this, but I've tried to highlight what factors companies might consider relevant for climate change initiatives. We've already heard a little bit about ESG, climate change, and how it's affecting investment arbitration already, but I did want to take an opportunity to juxtaposition ESG against what I believe is its progenitor. When I started my legal career, there was something called corporate social responsibility, which was considered the buzzword. Nowadays, I think that it's been replaced by ESG. But I believe the two are connected. As I mentioned, CSR, I believe, is a progenitor to ESG. CSR is a business model. It's a strategy that companies adopt. It's a philosophy that they would employ to enhance a particular societal or environmental aim. The problem with CSR was that it was too conceptual and very hard to evaluate. And I think that's why, in part, ESG was created, to solve that problem. And it's through ESG metrics, data, and reports that companies can better achieve their CSR goals. Accordingly, ESG acts as a quantifiable stamp of credibility on the broad management philosophy of CSR. I mention this because I don't think the debate that we're having today, whether that tension that I was describing before is entirely new. I think the same debate happened when CSR came out and became the buzzword, and it was highly criticized and eventually took a back seat to what we now consider ESG. I do notice a distinct difference, however, between corporate social responsibility, which does put a lot of onus on the corporation to be responsible, whereas ESG refers to environment, social, and governance, which are three things that I believe both states and investors can get behind as being positive value initiatives. And so what we've seen recently is that ESG has become an increasing focus for both states and companies alike. It has become a focal point for development of best practices by companies when encountering these ESG matters, as well as a tangible and meaningful way for states to regulate. Against this backdrop, there are two key developments that I believe that are resulting from the ESG, if I may call it, revolution. And these are increased disclosure and due diligence obligations. You may have noticed over the past few years, I want to say last 7 to 10, companies are more frequently publicly disclosing their ESG efforts and labeling it as such. What was once referred to as a CSR report or sustainability report are now considered ESG reports. These are usually done voluntarily and with the aim, usually with the aim of garnering some goodwill by those considering investing in the businesses. The timing of these disclosures also aligns with the establishment of certain other initiatives. For example, the Task Force on Climate-Related Financial Disclosures, which is an advisory body set up by the G20 to address concerns around insufficient disclosure of climate-related risks and opportunities for businesses. It started as a voluntary disclosure guideline, but it has rapidly influenced the establishment of several mandatory reporting frameworks in many jurisdictions. And I believe the UK and Switzerland are two that are leading the charge on that front. Another initiative that has happened in Europe has been the Corporate Sustainable Reporting Directive, or CSRD. This came into force in January of 2023. Through the CSRD, there are 12 underlying sustainability reporting standards that companies that have the CSRD applicable to them are required to report on. Previously, under the previous, I should mention, there was a previous, or there is, or was a previous convention in place that did require large companies to report on certain non-financial indicators. With the introduction of the CSRD, however, that is going to include not only more substantial reporting requirements, but also expand to a number of other companies, small and medium size, I believe. There was one source that I found that said current reporting requirements are roughly cover about 1,200 companies and groups within Europe. That number will increase to close to 50,000 once the CDSR fully becomes applicable. Even though it's in force, it does not actually apply until the financial or fiscal year of 2024, so reporting won't actually happen until 2025. I've also included on here that there are disclosure obligations at a domestic level as well. The Dutch Civil Code, for example, I'm presently residing in the Netherlands, so I thought it apropos to mention the Dutch Civil Code. They do require large companies to report on their non-financial performance indicators. Another initiative that's happening, and it hasn't been adopted yet, is the EU Corporate Sustainability Due Diligence Directive. Now, if adopted, this directive would introduce requirements for companies to identify and prevent, bring to an end, or mitigate the actual and potential impact of their activities on the environment. It would oblige them to conduct due diligence not only in their own operations, but also on the activities of their subsidiaries and other entities in their value chains in which they would have direct and indirect established business relationships. They would need to develop and implement prevention action plans, obtain contractual assurances from their direct business partners, as well as comply with plans and subsequently verify compliance. I regard this one particular directive, although it's only a proposal. There are other proposals in effect right now, or in place right now as well at the EU level. But I find this to be quite a fantastic obligation on companies to somehow ensure their ESG targets. It's quite onerous. It's almost the creation of a corporate duty, which I haven't seen in similar fashion. So this is going to be interesting to see if this actually happens. And this also, I'll loop back to Professor Wallace's question in a sec. On this next slide, what I've attempted to do was actually question at what point can ESG have a role in an investment arbitration. And I've identified on this screen moments where I think ESG initiatives, particularly things that are being disclosed and possibly even the due diligence reports that will be and due diligent actions that will be followed up on, will have some play before an international arbitration. Investment arbitration. I also attempted to link these to the general principles of law that I initially mentioned or quickly canvassed earlier in this presentation. And what you see here is, for example, well, I should also mention that whenever ESG initiatives are being discussed, I think that it's probably going to factor into the facts of any given case. What the investor did, what steps they took to before investing, how the state regulated, all these things will factor into the factual narrative of any given particular dispute. However, where I think the general principles of law can benefit from development and from international investment arbitration is through looking at how ESG initiatives
Devin, you have 4 more minutes. You have 4 minutes.
Or regulation happens at these particular points. For example, with fair and equitable treatment and legitimate expectations, there may be some risk management assessment happening here, particularly with the investor's ability to conduct due diligence or proper due diligence in the wake of certain environmental activities. And here I thought the prevention principle, namely to take preventative measures in anticipation of environmental damage, as well as the precautionary principle to not risk taking action or introducing a policy or product that has a risk of harming the environment if there's not scientific agreement on it. I thought that this is a point where these items are, this type of analysis could affect the development of these general principles. Similarly, procedural propriety, the notions of informed consent, cooperation, consultation, environmental impact assessment. I think some of these have already reached investment arbitration cases as between how states regulate and investors wanting to develop natural resources, for example. With expropriation, certainly reliance on general principles of environmental law can buttress the police powers doctrine when trying to justify what would otherwise be an unlawful expropriation. Kiran has already discussed counterclaims, and also Herfried has already discussed damages, but I think polluter pays was a general principle of environmental law that could be applicable in those circumstances. So I just want to go back to Professor Wallace's initial question about how would ESG obligations be imposed on investors. And I think one point is because they welcome it. It's consensual. And there may be reasons why they want to do that. For one, it could give them readily accessible or access to something like arbitration. Fair arbitration, in the sense that if they've participated with ESG measures, done their due diligence, prepared, disclosed all their information, complied with the law, they could, for example, if the state is acting what they perceive as incorrectly, go straight to an emergency arbitration and have a quick result and not have to go before the domestic courts to resolve the matter. That's one instance. Another instance might be that with all the disclosures that were going to be happening, we'll have a better insight about what the market is going to be like on ESG. How are other companies dealing with ESG measures and the laws? And that's going to hit them or set the market or the industry standard. And companies can look at that and question whether they're being treated differently by a state. For example, raise a MFN or a national treatment type claim based on that differential treatment. Now, if they choose not to
1 minute, Devin.
Thank you. If they choose not to comply, these things may come out, as I mentioned, in adverse facts. It may also come out in adverse finding and liability, how they've appropriately managed the risk. For example, their expectations may not have been legitimate. Similarly, with the counterclaims, it could dilute a potential claim, either in counterclaims or at the damages level. So with that, I will take us to the last slide. This last slide just summarizes what I have covered. I think the one point that I wanted to draw out from this final slide is the last point. And just to note that I have attempted to show how investment arbitration can influence the development of general principles of law, but that is not to minimize that you can also look to other areas that this ESG is being considered. before legal forums, particularly domestic or national level or supranational level, primarily where there is a private actor that is questioning the actions of a public actor, and in relation to these recent developments. So with that, I will close and hand the floor back over to Professor Wallace.
Devin, thank you so much. Incidentally, even as the EU is, of course, a good deal more active than the US, the Securities and Exchange Commission has also contemplated a disclosure requirement in which not only would the company have to disclose its own practices, but it would also have to reveal what its customers are doing, which is similar to the EU.
Yes.
At this point, Herfried, back to you.
Yes, the first thing for the participants, if you have any questions, please put it in the chat mode. You may also raise your hand. As I understand, we will not see you, but you can make questions. So please go ahead to put on the questions. Just a couple of comments, and I suggest we do a bit of a discussion until the questions come in with respect to the corporate EU corporate sustainability due diligence directive. I would like to draw your attention to the previous seminars we have been organizing together with Nivalion on that topic, on the EU draft directive, which has been substantially modified by the Council in September last year, and actually directed the whole damages part, because there's a substantial damages part in that directive with respect to European continental law, which adds additional elements such as the protected goods in case of a tort law systems. And there also, I would like to draw your attention to the leading cases, which is, for example, the Shell case in Amsterdam, that has been extensively explained by at least 2 speakers on those videos that can be found on our webpage. In particular, the General Counsel of the OPEC that had participated as speaker, and other experts that described the Shell case, where Dutch courts substantially increased protection under tort law for environmental damages, and not only that, confirming also jurisdiction, which is another issue. So Dutch courts have sustained jurisdiction with respect to environmental claims against Shell, and that's not the only one. One of the last videos by Mr. Wesemann, who is an entrepreneur with an Austrian startup, and he actually engaged in a climate action against the former Brazilian president Bolsonaro before the International Criminal Court. So if you want to listen to war stories, please look at our webpage to the previous seminars. And also the last one, which dealt with the other aspect that Kiran Gore mentioned today, cost. Yeah, and also Devin Bray, the backlash that is happening because of the enormous cost related to the upcoming EU Corporate Sustainability Due Diligence Directive, that is basically obliging any company selling more than $15 million to the European market to obey to that directive through the whole supply chain. And you can imagine that's a substantial burden. Actually, one of these enclosures annexes to the EU Corporate Sustainability Due Diligence Directive contains an annex of all legal norms to be applied on that directive, and that's from human rights to environment, whatever you can imagine. It's a whole bunch of legal obligations to be imposed on supply chains and to the last supplier in whatever country when the goods end up in the European Union. So it's just a couple of comments to the topics raised today. I don't know, Don, do you have questions to us? I'm still not seeing any question from the audience. Please don't be shy. But Don, for sure, with respect to the presentations today. You might have some questions to us and for the next 2 or 3 minutes.
I might go back. So I don't see any questions either. I think I see how this works. Herfried, on the damages, the initial draft of the UNCITRAL Secretariat for Working Group 3, I have to be careful since I'm on the U.S. delegation, but I found it, scandalous is too strong a word, but it was certainly naive in many respects. Because in reality, it's not clear that how the work of the UNCITRAL Working Group 3 will become binding on countries. It will not unless they agree. Each country has to agree to them, of course, and it's not clear what the final drafts will be. But I think the process. I think the final draft. I think will be a lot more conventional. On this business of counterclaims, I do think that's the future. I've thought so for a long time. As Kiran pointed out, the UNCITRAL and ICSID rules have always permitted counterclaims. The problem has been the issue of consent. The investor has not bound itself. And of course, the reason is clear. These were originally treaties to promote and protect investment against host country action, government action. Now the world, as we've had more and more arbitrations, and as you point out, Herfried, by and large, they're not just a run against governments where investors make enormous claims and then governments end up paying them. Far from it, as you pointed out, 54%, I think, of all claims have been decided in favor of the respondent. Furthermore, there have been many cases settled at much less than was asked for. And I think the system is, quite frankly, working well if you eliminate the outlier cases, the Yukos and the 2 or 3 others. And so what I feel is that, and this is a capitalist speaking, that the investor-state dispute settlement machinery has become, in a sense, the scapegoat for various anti-nationalist, sort of anti-capitalist, anti-international economic sort of phenomena, but they're inevitable. Life is tough. Countries want to develop. In order to develop, they need the expertise, the capital, the access to markets that the foreign investor brings. And as Devin points out, these investors are not all, rapacious capitalists in some Marxist caricature. They're complicated enterprises themselves. They want to do good. And in America, which is an unusual country, there's been a backlash at the suggestion they should do good. Lawrence Fink has been blasted as the sort of the George Soros of the times. But I think it will balance out, and having these kinds of discussions, which get you into the real detail of what ESG implies, I think is very valuable.
Yeah, thanks for your comments. Kiran, do you have any comment to what Professor Wallace mentioned with respect to counterclaim?
No, I just want to add that, and I did not have the chance to say this during my presentation, but the right to regulate has been introduced now into the more modern treaties in a few different ways. One is the obvious place, which is the preamble, that it's no longer, as what Professor Wallace described, a invitation for foreign investment to protect the investor, but it's sort of a bilateral promotion of a sustainable environment and to facilitate foreign investment in support of that environment type language that you're seeing in the preambles. There are a few other places where it also starts to come up, including in the fair and equitable treatment clause. So as you start to create more balance in the overall treaty, including the right to regulate as a national host state objective, that's where the room to create obligations, binding obligations, concrete obligations, as Devin described. I think he's quite right that CSR, corporate social responsibility, was such a buzzword for a long time, and then everybody said, oh, well, it doesn't actually mean anything. It just feels good to talk about it, but it doesn't actually mean anything. But ESG, including some of the more binding, corporately binding obligations that Devin describes, coupled with right to regulate, Paris Agreement, OECD multinational guidelines, these are concrete metrics that are being incorporated not only into the corporate requirements, but also into the national laws. And that creates a great opportunity. So
I will just wrap up very quickly. Just an announcement, the last webinar. Well, first of all, thank you all for participating at today's webinar. That was really interesting, and hope people will like the video and the Clue Arbitration blog, which we will forward on today's seminar. The last seminar will be on the 13th of December, which deals with climate change and commercial arbitration, with Kevin O'Gorman speaking on the role of international arbitration in the adjudication of historic mass claims. Nathalie Allen on why international commercial arbitration is perhaps not the best vehicle for climate change related disputes. And Patrick Tiffrey, one of the authors of the ICC study on climate change, on possible adaptations of commercial arbitration for climate disputes resolution. I would also like to thank Nivalion, the Swiss third-party funder, on having organized these rather long seminar series with us. I think this is the 14th webinar we have been doing. The first two were very large ones, in particular on the EU directive. And finally, would like to thank the sponsors, the Mexican Arbitration Center, Green Arbitrations, the Chartered Institute of Arbitrators, the North America branch, the Transnational Dispute Managements, the Swedish Chamber of Commerce Arbitration Institute, the Vienna International Arbitration Center, and the ICC Austria, of being our trusted partners in these webinars. I hope they're useful. Its aim is to do in-depth analysis on these topics. And thanks again, Don. Thank you, Kiran. Thank you, Devin, for participating in today's
seminar. Goodbye.
Thanks a lot.
Hasta la vista.
Bye. Bis bald.
Thank you.